Good morning. Well, given the economic context, as Don has outlined, in recent years, the effectiveness of employment standards and their enforcement has become a pressing concern among policymakers and workers' advocates. In Ontario, as elsewhere, declining rates of unionization are fueling the growth of precarious employment, characterized by low income, a lack of control, and limited access to regulatory protection. It's therefore increasingly the case that employment standards, legislating minimum conditions in areas such as wages, overtime, vacations, etc., are the only source of workplace protection for a mounting number of workers in the province. And in Canada, as elsewhere, employment standards enforcement agencies are seeking out new ways to manage the expanding mandate that they have been given. And it should be acknowledged that they're doing so under conditions of limited resources. In my few minutes this morning, drawing on some early research findings of a community university research partnership on closing the enforcement gap, which I oversee, I want to highlight three key areas in which Ontario has made considerable progress, but where more progress is needed. These areas relate to coverage, specifically expanding the population of workers who are actually covered by employment standards, improvements to workers' access to the enforcement system, and further investment in proactive and deterrence measures. Now, coverage is a key starting point. After all, it concerns the fundamental question of who, in this case, the Employment Standards Act, or the ESA, is designed to protect. Considered broadly, several large categories of workers are formally exempted from the Employment Standards Act entirely, including workers who aren't classified as employees, such as independent contractors, even though they resemble employees in some cases. Other types of workers, often at the margins of the labor market, have been poorly served by the ESA because of the nature of their employment. Here, I'm thinking in particular about migrant live-in caregivers and temporary agency workers as key examples. In recent years, Ontario has made considerable efforts to extend better coverage to workers engaged in such precarious forms of employment. But there is a need to do more because of the tattered employment standards enforcement quilt, which is characterized by a patchwork of full and partial exemptions. Yet to be confronted, but requiring improvement in my view, are the different levels of coverage that the Employment Standards Act establishes for different types of employees. So the ESA provides for a number of what might be called partial exemptions, most of which are based on the type of job a person holds or the type of workplace. For example, certain types of farm workers are exempt from employment standards provisions around minimum wage, hours of work and overtime, and employment standards rules on personal emergency leave apply only to employees in workplaces that regularly employ more than 50 employees. So drawing on data from Statistics Canada, we can see how these exemptions affect some groups of people, some of whom Don has talked about, more than others. So this chart shows that with respect to the employment standards categories of minimum wage, overtime, public holidays, and severance pay, workers in the lowest income segment are least likely to be fully protected by the law. That is, to be subject, so they are more likely, therefore, to be subject to a special rule or a stipulation that gives them less than the Act stipulates as a default or a general provision. Low-income workers are 10% less likely to have minimum wage coverage than other workers, and only 29% of them are fully protected by overtime rules. Now, my next slide shows that Ontario's youngest workers, those under 30 years of age, are least likely to have full coverage under a number of employment standards provisions. Improving employment standards, therefore, involves both continuing to expand coverage under the Employment Standards Act and limiting partial or complete exemptions for workers that are formally covered. Exemptions that, as I've tried to illustrate, disproportionately affect those belonging to certain groups. In the U.S., Next month, the Department of Labor will be announcing new regulations that crack down on overtime and other exemptions. And a similar rethinking of unprincipled exemptions, I think, is needed here in Ontario. Moving to the question of improving access, another area we've seen improvements, but which requires still greater attention, concerns workers' access to the complaint and enforcement process. Laws on the books mean very little if workers aren't able to see their effective enforcement. Ontario has taken some important steps to make the complaint system more accessible. For example, there's more information now available in many different languages. But the complaint system remains reactive, often inaccessible to workers who remain on the job and fear retaliation, which can be subtle and difficult to substantiate. Also, in Ontario, there is no provision for anonymous or third-party complaints, nor is interim reinstatement pending an investigation available to fired workers. So given such barriers, most workers file employment standards complaints after they've left their job. And a reform adopted in the 2010 Open for Business Act that most workers must first seek resolution with their employers before accessing the complaint system reinforces this tendency. So this chart, which appears in the 2013 report on plans and priorities published by the Ministry of Labor, indicates a reduction in the number of claims received following the implementation of such reforms. It depicts a decline in the number of claims of almost 25% between 2009-10 and 2012-13. Of course, research over the long term is needed to determine the precise cause of this shift, but it likely stems, at least in part, from the increased requirements placed on claimants in the complaint process. Outside Ontario, in other provinces and a number of U.S. states, there's been a movement in the opposite direction by, for example, permitting employees to submit complaints and evidence anonymously. Another tool for lessening the potential damages to workers that opt to complain is known as a presumption of employer retaliation. This type of thing is adopted in New York State, and it involves creating a legal protection for workers against retaliation. The device essentially means that any adverse action against an employee within a certain time after a formal complaint is lodged is simply deemed to be retaliatory. Such measures alleviate the risk of complaining amongst complainants. So repairs to the complaint system should, of course, also be supplemented by providing for greater avenues for collective action. One practice that's taken up in other jurisdictions is to support collaborations, where workers' designates, they may be business agents from unions, representatives from entities that work with non-unionized workers like legal clinics and worker centers, are deputized to assist in the enforcement process towards similar ends. And these measures, these types of measures could go, I think, a considerable distance in facilitating worker access to the complaints and investigation process. So I now want to move to my third and final area where we've seen improvements in employment standards, but where more work needs to be done. And this is the need for greater investment in proactive and deterrence measures. Like many jurisdictions, Ontario's enforcement system is driven by complaints, as I've shown. The bulk of resources go to the investigation and resolution of individual complaints. Yet research shows that complaints are only the tip of the iceberg. Harvard economist and now head of the U.S. Department of Labor's Wage and Hours Division and a participant in our project, David Weil, has estimated that for every one complaint lodged, there are about 130 employment standards violations in his context, and that this ratio fluctuates across industries. Furthermore, research shows that many sectors characterized by high rates of violations generate few complaints. And this makes proactive strategies critical to enforcement. Proactive enforcement relies heavily on targeted inspections when violations are detected. And the underlying assumption of this strategy, which is known as strategic enforcement, is that a proactive approach will not only detect and underreported violations, but that the fear of possible inspection will simply improve compliance. In Ontario, these types of inspections have grown over the last decade. Recent blitzes have followed a strategic enforcement approach by targeting sectors where violations are known to be common, including in the temporary help agency sector and among temporary foreign workers and interns, a group that Andrew Langille will speak about. But proactive inspections are just one side of the enforcement coin. The other consideration is how violations are addressed and deterred. It's common to understand enforcement as a pyramid involving less severe measures at the base, but moving up to what are called deterrent measures in the case of more serious violations. Historically and to the present, as depicted in this diagram developed by our team, the bulk of enforcement resources have gone towards resolving individual complaints through voluntary settlements or compensatory orders. Deterrence tools that impose a penalty, including notices of contraventions, tickets, and prosecutions, are rarely used. For example, researchers estimate that in 2010-2011, there was roughly one deterrence action for every 22 detected violations. So the problem is that a low likelihood of being caught and only having to pay what was originally owed, if caught, creates strong economic incentives to violate the law. While underutilized in Ontario, the principle of deterrence is central to any effort to improve the efficacy of employment standards enforcement efforts. So to conclude, ensuring that employment standards can provide a basic floor requires, in my view, improvements to the scope of their coverage, ensuring that workers have access to enforcement when they confront violations, and greater space for enforcement activities that are both proactive and deterrent when it's necessary. With declining job quality, more people in precarious jobs, labour ministries in Canada are facing similar challenges to those in other countries. And as concerned thinkers, public administrators, policymakers, I think it's incumbent upon us to pay greater attention to the lessons learned and the new models of enforcement that are emerging in other contexts and to what the data are showing us. Thanks very much.